Hi, it's Dennis Daly. When was the last time you attended a courtroom trial, or maybe served on a jury, or watched a trial on television? There's a question, particularly in the wake of the O.J. Simpson trial, as to just how many cameras, if any, should be allowed in a courtroom. I interviewed two people who wrote a book called Cameras in the Courtroom and found that it's a complicated issue. Many high-profile trials in recent years have sparked a great debate on whether or not there should be media access to courtroom proceedings. There's a wonderful new book called Cameras in the Courtroom, and one of the authors is CBS News correspondent David Dow, whom I have long admired for his work on many news stories. David Dow and Marjorie Cohn, who is a professor, met each other when they were covering the Simpson trial, and through their long conversations they decided to write a book. And the book is called Cameras in the Courtroom. I sat down with David Dow and Marjorie Cohn in the studios of KNX here in Los Angeles and talked about the history of media coverage, and mentioned that when I was in school we talked a lot about the coverage of the Scopes trial in the early days of radio.
The Scopes trial, in terms of the issue of whether broadcasting entities should be allowed into courtrooms or not, didn't generate nearly the emotion that the O.J. Simpson trial of its age did, which was the Lindbergh kidnapping trial.
Yes.
That was the first trial where, unlike the Scopes trial, where actual cameras and the television cameras of their age, movie cameras, were in a courtroom. And it was out of that case, rightfully or wrongfully, that a lot of the prohibitions that dominated the relations between the media and courts for decades after that were born. There was a lot of blaming the messenger because the Lindbergh trial was, as was said of the O.J. Simpson trial, that it was a circus. And of course it was a trial that brought out celebrities to the gallery and brought out a huge crowd of news people, just as the O.J. Simpson case did. And this, of course, was back in the early 30s.
Marjorie, the constraints that are put on the media, are these local, state, national? Can you put into perspective at the current time who decides or what decides whether there will indeed be various levels of coverage?
Each state has its own rules governing camera coverage. And 48 out of the 50 states allow some type of television in the courtroom. Also, the federal courts decide whether or not cameras are allowed in federal courts, and they basically are not, with very few exceptions at the appellate level. But each state has its own rules. In most of the states, the judge has discretion to allow the camera or kick it out. In some states, the judge asks the parties, in particular the defendant in a criminal case in many instances, whether or not they object to camera coverage. There are different guidelines from state to state.
David, you took your journalism training where? The reason I ask is that when I was going through school at Indiana University, I can't think of a single time in which journalism in the courthouse was actually even mentioned in class. I mean, we did those boring city council meetings, but yet I can't remember having any input from any of my journalism professors on how to cover a court case.
Well, my communications major came from Stanford University. My recollection is there was one course, it was called something like Covering Public Affairs, one semester, which embraced, as you say, city council meetings, boards of supervisors meetings, and the courts, and we got a little sample of each. The issue of cameras in the courtroom was not even mentioned, I am sure, even though that's now many years ago, simply because it was a very dormant period for that issue. I was in college in the late 50s when basically there were almost no cameras in any courtrooms in America, and the atmosphere was dominated by a quasi-legal code of the American Bar Association, which in effect barred cameras from courtrooms. So it was a non-issue at that time.
There's also something else, and I was talking to a friend the other day who does not live in L.A., and he said, how come everything that happens in L.A., we see it? Every time there's somebody being chased by the police, we see that. And the reason is there's just so darn many cameras anymore. I mean, when I was covering the Simpson trial, I did a survey. There was nearly $2 million worth of camera equipment ringing that courthouse one day. And I really think that part of the reason why we have all these questions now is they're not necessarily cheap, but cameras are everywhere. And we could have put cameras in the courtroom years ago. We had the technology, and it was being done, but there was not this proliferation of equipment. Maybe I'm being too technical here, but I've always thought that we now have a situation where we can cover everything in much more minute detail.
It's interesting you should say that, because for the most part, trials that are televised today are broadcast through one remotely operated camera, either on the ceiling or mounted above the jury or behind the jury box, such as in the Simpson case, so they're much less obtrusive, and I think this is one of the reasons that judges may not object to them quite as much, because the physical camera itself is not as intrusive. Now, the effects of the televising may or may not be obtrusive, and that's a different issue.
And you've also touched on another development in this whole running saga, and that is your friends who say they're seeing more and more things on television in California are probably not seeing more and more from courtrooms in California. One of the offshoots of the O.J. Simpson murder trial was in fact a backlash that was most pronounced here in California against cameras in the courtroom. For the most part, that backlash was short-lived in other states, but it persists to this state. The Rule 980, which governs the admission of cameras to California courtrooms, was rewritten so that in effect a judge for no reason at all can bar a camera from a courtroom in California. And in fact, fewer and fewer cameras are getting into courtrooms in California at the moment.
Have we seen cases where the presence of a camera during a trial became some grounds to appeal later?
Yes, in the mid-'60s, the Supreme Court grappled with that issue in the case of Billy Saul Estes, who was convicted of swindling, and whose conviction was overturned on appeal because the Supreme Court thought that the presence of cameras in a small part of his trial had actually denied him the right to a fair trial.
You talk about the sometimes single camera that is in a courtroom. Is this often remotely... Boy, I'm going to coin a word. Manipulable? Let me start that again. I'm getting myself into a box. I can't think of the proper word. Is there remote control on a camera where the director, if you will, can decide what the audience at home sees, or quite often is it just a static camera?
Typically today you've got one of two situations. You have almost always it is one pooled camera. In other words, one camera in the courtroom shooting the proceedings for a number of news organizations. That's to keep down the baggage, if you will. It can be one of two situations. A traditionally, conventionally operated camera, almost always fixed, usually in a remote corner of the courtroom, the back of the courtroom, one camera operator, no lights, and depending upon the rules of the court and the rules of the state, he may be limited in what he can actually depict in that courtroom. For instance, in California, with the new Rule 980, you can no longer show audience shots. You can no longer show the kind of gripping shots that were so typical of coverage of the O.J. Simpson case. Or the state-of-the-art, if you will, and this was used during the O.J. Simpson case, was used during the televised Menendez brothers trial. Of course, there were two, one non-televised, and that is a remotely operated camera which can be placed up on a wall, can be placed anywhere in the courtroom, and the operator, using a sort of joystick, can be remote indeed from the camera itself, playing his camera much like you'd play a video game.
Inherent in this, though, is the question of the power that the director, the person moving that camera, has. It's the old thing about Capitol Hill when C-SPAN first went there, and we saw these wonderful sessions where it looked as though a congressman was railing up there and nobody was there because they never showed the empty gallery. Is there not a lot of area for, if not abuse, at least you create another layer there where one person decides what you do and don't see.
That's true. The person with the joystick may be actually manipulating the camera, but in the O.J. Simpson case, we were told that news directors from other parts of the country would tell that remote director or the person that was manipulating the joystick to shift a little more this way or a little more that way, so that we saw those shots of O.J. Simpson, and then those would be juxtaposed, his face would be juxtaposed against shots of then the spectators weeping in the gallery. And so the decision how to place that camera is an editorial decision, and many people say that actually interferes with this kind of objective, let's show it all and let people decide, because of the editing process that goes on and where to put the camera and how to juxtapose the different shots.
When you televise a trial, inevitably you're going to have two trials. You're going to have the one that you'd see if you were sitting in that courtroom, and you're going to have the one as seen by a television audience. And the differences can be minor or they can be quite substantive. Let me explain what I mean. They can be minor in the sense that if you're sitting in the courtroom, you see it all. You see the weeping victims' families. You see the defendant sitting there with whatever emotion he happens to be exhibiting at the time. A camera, which may be shooting from a fixed position, may have a much narrower range of view than you do, and may be focused simply on the person testifying, so it's going to look different. Those may seem to you to be cosmetic or minor differences, but think of the O.J. Simpson case, where a television audience was treated to the full array, all 50-some-odd examples of Mark Furman's expletive-laden, racially overladen remarks to a screenwriter, and Judge Ito finally allowed just two of those examples in as courtroom evidence. That's what the jury heard, were two examples. We in the television audience heard all 50-some-odd. The impact could be quite different, and hence the view of the trial could be quite different.
Marjorie, in carrying this one step farther, I remember after the Simpson trial, and I pale in my knowledge of the trial and legalisms and the legal profession to you two. But I remember having several conversations in saying, look, we weren't there. We saw what we saw on television. We were not the jury. We were not denied access to certain things when they were in private. We were not shown things that were at home. And it would seem that, particularly in a national trial such as this, where you have such strong feelings from the public, that you actually, in a way, damage the court system, because it's so hard for people to understand, as you say, that they got one trial and the jury got another. It would seem that there can be a very easy criticism of the jury or the court process, because we're not seeing the whole thing.
You know, even if this were not the case, that certain evidence were to be excluded from the consideration of the jury, that evidence which was seen by the viewing public, nevertheless, a person at home would have to watch every single minute of that trial in order to see what the jury saw.
It seems to me that inevitably there's going to be some element of that, whether a television camera is in the courtroom to record or broadcast it in its entirety or not.
Marjorie, I must ask you this then. The nuances of what happens in the courtroom, in the long haul, across the whole trial, I would take it from the standpoint of someone who has been involved in that there's an awful lot of weight that happens in the jury's decision. An awful lot of the jury's decision is based upon not so much the dramatic statements, but maybe their perception of watching the defendant during the trial. Can you talk about that, those things that really, as David said, were not sitting there during the entire trial, what an impact that has on the final verdict?
Yes, you know, every jury decides a case based upon factors that in most instances, cannot be predicted. I was amazed when I did trial work to talk to the jury afterward and find out what the basis for their decision was. And certainly the jury does see things, expressions, as you say, nuances in the courtroom that the viewing public may not see, and makes a decision based upon the collective experience of that jury in the context of this case. That's very different from the court of public opinion, the armchair juror sitting at home in his or her living room and making a determination based upon whatever bits and pieces of the trial he or she watched, and missing many of these nuances that really affect the jury's decision ultimately.
You know, I think there's one other dimension of this that ought to be brought up, that regardless of the shortcomings, regardless of the inevitable problems of this two-camera dichotomy or two trial dichotomy that we have, the trial is seen by the people in the courtroom as opposed to that seen by a television audience. I think that televising trials undeniably does contribute one great positive factor, and it's contributed to the education of a lot of people on the reality of the law. And I think there's little denying that the judicial branch of government is the least understood branch of government. And regardless of what people may have thought about telecasts of the O.J. Simpson trial or the Menendez brothers trial, I think a lot of people were educated to some of the realities of everyday courtroom activities, even though there was some aberrant elements to the Simpson trial and indeed to the Menendez brothers trial, but there was still an awful lot of good, solid, basic bedrock law that they were educated to.
Well, I think a lot of people whose perception of the court system is Perry Mason suddenly had to come to grips with the fact that this doesn't happen in 30 minutes, that this goes on, and you're leaving and going back to chambers and coming back and excusing the jury and bringing them back, that it can be a tedious time. And in this generation of short attention spans, it was a lot of reality for people to realize just how tedious a trial can be.
That's true, and whereas, as David said, many people watching on television received a primer in the Fourth Amendment, in due process, in constitutional rights, and how a trial functions from watching parts of the O.J. Simpson trial. Another effect that it had was to raise the expectations of jurors in unrelated cases. For example, there have been accounts of jurors in cases in Northern California who would acquit a defendant because the prosecution didn't present any DNA evidence. Because having seen the Simpson case, where 3 laboratories tested the DNA, that's what people now expect.
One size fits all.
Exactly. Yeah. And how many defendants have the wealth to hire a dream team the way O.J. Simpson did? So in that sense, it's not really a typical representation of the criminal justice system.
In your book, you refer to the audience at home as the 13th juror. Now that we've had so many televised trials, and we've seen so many cases where CNN or CBS or whoever it is debriefs the jurors after they're released, what goes through the mind of the jury? They're on television. They know that if it's a very high-profile trial, they're going to be grilled after all of this is over.
It is true that when a jury knows that a case on which it is sitting will be televised, it does signal to the jury that this is a particularly notorious case. And many jurors may also feel that they have increased accountability to their community, so that when they go back to a community with law enforcement relatives or friends, how are they going to justify voting for an acquittal? And that may well cut against the defendant's right to a fair trial.
When cameras have not been permitted in the courtroom, what have been the common rationales? What have been the most common reasons that the judge has decided, let's not do this?
In the Susan Smith trial, which came after O.J. Simpson, the judge excluded the camera because he was afraid that witnesses who might give favorable testimony for Susan Smith in this small town of Union, South Carolina, may hesitate to come forward and testify for her because they knew that their testimony would be broadcast to millions of people.
David?
Well, in California, where I do most of my trial watching, the most common rationale for barring a camera in California courtrooms has been 3 words or 4 words: the O.J. Simpson trial. It has. I think the last 5 instances where I've seen a camera barred from a courtroom, a judge has said something, "I don't want another Simpson trial."
Former CBS correspondent David Dow and his colleague wrote the book Cameras in the Courtroom. I'm Dennis Daly.